Morning, folks. It's 9 o'clock. Welcome to Federal and State Affairs. First up, bill introductions by committee. Representative Hoyt, you have a bill introduction?
Yes, thank you, Mr. Chair. I have 21 RS 0650, a domestic violence bill that would require a relinquishment order of firearms upon the issuance of a qualifying protection order or conviction for domestic battery or domestic violence misdemeanors.
Thank you. Matt, do you have that? Matt?
Yes, Mr. Chairman, I do.
Thank you. Without objection, it's admitted. Representative Epley?
Challenging with this mic. Can you hear me now? Okay, so it's RS 0731, and it is an act concerning the disposition of certain state real property, authorizing the State Historical Society to convey certain real property located in Donovan County as it relates to certain conditions, costs of conveyance.
Thank you. Any questions? Seeing none, without objection, it's admitted. Other bill introductions by committee members. Representative Burris, do you have a bill? Thank you. Bill introductions from the audience. Seeing no bill introductions from the audience, bill introductions is closed. I'm going to ask our IT fella to tell me who's on remote. Go ahead. Can you turn the mic around? Or does your mic on your computer work?
We have Jordan Mahalahan, Matt Sterling, Mike Heen, Michelle Segan, Tori Marine Armberger, and Trevor Jacobs.
Thank you. Did you get that? Good. Our vice chair is not here today because of other business. I've asked Representative Smith to sit in her slot because we may have questions, and he will help me identify where the questions are coming from. With that, I'm going to open the hearing on House Bill 2087, limiting the review of certain rules and regulations by the Director of the Budget. We have three proponents. First up will be the Honorable Representative Ron Hyland. Representative Hyland, welcome to Federal and State Affairs Committee. You can take your mask off while you're speaking.
Thank you, Mr. Chairman and members of the committee. This bill came through this committee last year, passed overwhelmingly. It was the next bill up to be argued on the floor when we stopped our legislative process last year. So it's a good bill. It came from the Rules and Regs Joint Committee, which I was a member of for several years. And I think 3 or 4 years ago, we brought out this bill and worked it to with all the different stakeholders. And the purpose was to, when an agency writes their rules and regs, we want to know how much it was going to cost our patrons out there, our constituents, how much it was going to cost to institute that new regulation. And it has had the desirable effect. What we found out was it was too much of a burden on the budget director, the state budget director. So what we changed it, and this is the cleanup bill to change that, to remove his authority for disqualifying any rules or regs. He cannot do that. So we've removed that. We've also said that if anything is below the $3 million 2-year accumulation of cost, then he does not have to review that. It overwhelmed their entire system the way we had it. So it's a cleanup bill, and we sat down with all stakeholders, worked out a compromise, and this is the result of that compromise. Because of its non-controversial nature, I think I would ask the committee to run this through as quickly as possible. Thank you, Mr. Chairman.
Thank you. Questions for the conferee? Seeing, oh, sorry, Representative Heiberger.
Hi, Ron. Thank you for being here today. Representative Highland. Do you have a copy of the bill with you? Do you have a copy of the bill with you? Okay. Yeah, could you look at page 3, lines 10 through 13, where it states that in determining additional costs of proposed rules and regulations, the state agency shall not account for any actual or estimated cost savings that may be realized by the agency, local government, or members of the public. The rationale for including that?
What page are we on now?
Page 3,
Yeah.
lines 10 through 13.
Through 13.
The part that says that cost savings won't be considered in determining the total cost.
Well, we wanted to know the total cost to the consumer, our constituents, when the regulation went through. If there were savings, then that just subtracted from it. We didn't make them report that to us. That's all that's saying.
Okay. Is that a change from current practice or not? Do you know?
It was something that they thought they had to do, and we said, no, you don't, so we made it clear.
Thank you.
Thank you. Committee, on occasion, I do make a mistake. I did not get an overview from the reviser. No further questions of representative, and then I'll go back to the reviser. Matt, are you on?
Yes, I am, Mr. Chairman.
Sorry about that. It's
Oh.
right on my agenda, reviser's overview of House Bill 2087. Could you give me that?
Absolutely, and not a problem. So yes, thank you, Mr. Chairman. House Bill 2087 would amend several statutes concerning rules and regulations and review by the Director of the Budget. Under current law, rules and regs, the approval process requires state agencies to provide an economic impact statement to the Director that considers the total annual implementation and compliance costs to businesses, local governments, or individuals, a determination of whether those costs would be more than $3 million over 2 years, and an estimate of those costs expressed as a single dollar figure. The Director is also required to make an independent determination regarding implementation and compliance costs, and may approve or disapprove of a rule and reg based upon the accuracy of the impact statement or determination that compliant implementation would be more than $3 million over 2 years. Additionally, if it's determined that it would cost over $3 million, the agency would also be required to conduct a public hearing. So under House Bill 2087, the bill would remove the requirement that the Director make an independent determination of the compliance cost and remove the provisions requiring the Director to approve all rules and regulations. The Director would not be required to review or approve rules and regulations if the submitting agency determined they would cost less than $3 million over 2 years. Under the bill, agencies would still be required to provide the Director with a copy of the impact statement. The bill would also specify that the implementation and compliance costs would be those costs reasonably expected to be incurred and would be separately identified for those affected businesses, local government, and members of the public. As raised in the question, in determining costs, the agency would not account for any actual or estimated cost savings realized by those entities. Additionally, if a state agency was proposing a rule and reg because of a federal mandate, the state agency would be required to provide an economic impact statement, but the Director would not be required to review or approve the proposed rule and reg, regardless of the estimated implementation and compliance costs. For those rules and regs that are proposed due to a federal mandate, compliance costs would be calculated from the effective date of the rule and regulation. And lastly, under current law, proposed rules and regs are submitted to the Director of Budget before being submitted to the Secretary of Administration and the Attorney General. Under the bill, agencies would send proposed rules and regs to the Secretary and the Attorney General before submission to the Director. And I'd be happy to try to answer questions the committee might have.
Thank you. Questions of the reviser? Questions? Referee would be, the next one would be Christopher Tyson. Yep. Department of Wildlife and Parks. Good morning and welcome to Federal and State Affairs. the mic on?
All right, I'll start again. Mr. Chairman, members of the committee, I am Chris Tymason, Chief Counsel for the Kansas Department of Wildlife, Parks, and Tourism. I'm here in support of House Bill 2087. We came before you last year and requested an amendment to then House Bill 2411, and that amendment is included in this draft. I am the person who does regulations for the agency. I'm the main point in the agency which interacts with the other segments of government. And we have about 180 regulations that we manage. The way our statutes are set up and the way the legislature chose to set up the agency back in 1989 when we went from Fish and Game and Parks Authority to Wildlife and Parks, the statutes say essentially you can't do any activity unless the regulations say you can. And as you know, hunting, fishing, parks, boating generates significant economic impact in this state. So it's very important that regulations are done in a timely fashion. The most important thing to me in this bill is to ensure that the Division of Budget is the final approver in the process. As it stands now, I take regulations to the Division of Budget, then I take them to the Department of Administration, where they might be cut a few times. Then they go back to the Division of Budget for approval again, and we work out that language again at Department of Administration. Then we go to the AG where there might be yet another change. And so because the Division of Budget only looks at the financial aspects of the bill, I think it's important that they're the final reviewer. It would save countless hours in this process for all state agencies, not just mine. With that, I'd be happy to stand for any questions and appreciate the opportunity to appear.
Thank you, sir. Questions? Seeing none, thank you.
Thank you.
Next up on WebEx, Adam Profit, Director of Budget. Are you there, Adam?
Yes, I am, Mr. Chair. Can you hear me okay?
Yes, sir. Go right ahead.
Very good. Thank you. Well, good morning, Mr. Chair and members of the committee. As mentioned, my name is Adam Profit. I am the Director of the Budget for the state of Kansas. I stand before you today as a proponent for House Bill 2087. You have my written testimony in front of you, but I will not be reading from that. I do encourage you to read through that at some point in time, but I'll just touch on the highlights right now if that's okay. So as mentioned, I am a proponent of this bill. This bill, I think, presents a unique opportunity for the legislature to enhance an existing process. And what it will do is both provide efficiencies throughout. You heard Mr. Tymason speak to some of those, but it also maintains the fidelity of the original intent of the law, whereby there is a review of the fiscal impact of any regulation coming before the state. So under current process, when any agency creates a regulation, it first starts with my office and it comes to me. My analysts go through and read it. They do their own economic impact review. They review that economic impact statement of the agency as well. And then it comes to my desk for review and approval. I then read every page of the regulation. I read the economic impact statement provided by the agency. I review the economic impact review from my team, and I determine whether or not that meets muster, and I stamp it and move it on. From there, it goes to Department of Administration for their review for technical corrections, typos, grammar, things of that nature. And then it moves on to the AG for a legal review, and then finally to the Administrative Rules and Regulations Committee to be moved forward. If there are any typos or any amendments by Department of Administration or by the AG's office, it then goes back to the agency. They fix those and they send it back to my team. We review that again and we re-stamp those pages and we move it on. If there's another correction down the road or something that somebody missed, it goes back to the agency, back to my department. We review it again. I stamp it and I move it on again. Under the new process, that will change a little bit, as mentioned, where I would be last in line and I would only be reviewing the high ticket and the high dollar items. So I must say that as budget director, I do appreciate the rigor that is built into this process. I appreciate that the agencies will still be required to do an economic review. They must review what the impact is going to be to the state, to the locals, and also to citizens of the state of Kansas. So I appreciate that that is maintained within this new bill. But I also appreciate that my team will not have to review anything unless it hits that $3 million threshold. This does a couple of things. first of all, like we said, it provides a lot of efficiencies because it sort of skips us until the end. So you're not waiting a couple of times for us to stamp that and then move it on to the next step in the process. But it also just makes sure that the Division of Budget has a say in the process if there is a high dollar item coming through to the tune of $3 million. Now, we submitted a report as required by current statute to the Senate President, the Speaker, and the Chair of Administrative Rules and Regulations just a few days ago for everything that happened in 2020. So in 2020, there were 455 regulations that came through the Division of Budget that we reviewed, analyzed, stamped, sometimes re-stamped and sent on. And only one of those regulations had a price tag of $3 million. Over the past 2 years, we've seen over 1,000 regulations, which equates to thousands and thousands and thousands of pages, and only 11 of those had a price tag of greater than $3 million. So that's about 1% of the regulations that come through that has a price tag of $3 million. So with this new process, what this bill will do is it'll take the 99% of the regulations that the agencies have already analyzed for an economic impact, and it will just forward that on to the next step of the process where you're getting some efficiencies there. But it also makes those 1% that do have a price tag of $3 million or more stop at my desk to make sure that I'm reviewing, and I can ask any questions along the way to make sure that it is both necessary and it's going to further benefit the state, and then we can move it on to the Joint Committee on Rules and Regulations. So again, I go back to my comments at the top. This bill is a really, really unique opportunity for the legislature to both increase efficiency within the state government, but also maintain that crucial component of a secondary review for any high dollar items that are going to come through. And with that, Mr. Chair, I would stand for questions if there are any.
Thank you. Questions for the Director of Budget? Heiberger?
Thank you, Mr. Chair, and thank you, Director, for being here. Do you have a copy of the bill with you?
I do. I've got it right up in front of me.
Yeah, could you look at page 3, lines 10 through 13, where it indicates that in determining the total costs of the regulation, cost savings shall not be considered?
Yes.
Is that current practice? You know?
I'll be very honest with you. I would have to go back and look at the bill. At times there are mentions of that, but we're looking at the total cost to anybody throughout the process, state, locals, or the citizens.
Okay, and the bill gives you the right to reject any regulation with the total cost of $3 million or more. Would you consider cost savings when making that determination, or do you?
I would say that my current process is to review the analysis conducted by both the agency and my division. If there are any questions, or if I see something that doesn't look quite right, I do pick up the phone and ask questions. I've sent a few back to the agencies to clarify. So if I think there could be potential cost savings that would be considered, then yes, I would absolutely pick up the phone and have that conversation.
Thank you.
Thank you. Other questions? Representative Arnkamp?
Mr. Chairman, Director, thank you for the numbers for the past year, and I think 3 years is what you gave us of the rules and regulations that you reviewed. And you said about 1 was over 3 million last year, and I think 11 for the prior 3 years.
The prior 2 years, yes. 1 this past year, and then 10 the year before that, yes.
10 the year before that, all right.
Yeah.
Do you have the numbers available of any rules and regulations that would have fallen between $1 million and the $3 million mark?
I do not have that readily available. I can try to go back through and see if they're on there. What we have is, there's a form that comes with it, and there is a question that says, what is the estimated total dollar impact? And then right below that, it says, is the total estimated dollar impact to exceed $3 million? And that's really the key for us to look at. Now, we do look at both. If it is 1, 1.5, 2 million, we'll kind of look at it. But the key here is it over $3 million or not? So we could go back through each of the forms. I would say it would be a rather laborious and manual process, but if that's the will of the committee, we'd certainly be happy to do that. I would just request some time to be able to complete that practice.
Go ahead.
Thank you, Mr. Chairman. Mr. Director, I don't think an exact number is necessary, at least for me. but do you have a rough, just random guess, maybe plus or minus 10 of the rules and regs that would fall in between the 1 million and 3 million mark? Would, if the number in the bill was reduced to 1 million,
Mhm.
how much extra effort would that put on your agency?
I don't think it's that many that are over $1 million. If I'm being perfectly honest, if I see $1 million price tag, it sort of raises my eyebrows to look at it a little bit deeper. The vast majority of these that are coming through are either no cost or negligible cost. Sometimes $1,000, sometimes $10,000, which is a lot of money to me personally, but for the state and the process that we work through. So I am guessing you were driving towards, if we lower the threshold towards $1 million, would I still be supportive? The short answer would be my preference would be to keep it at 3 million. I believe Director Campbell, who was the budget director prior to me, pushed for a $5 million threshold. If this committee chooses $1 million, by God, we'll adhere to that and we'll move forward with it. And I don't think it'll be an undue burden on us. But my preference would be 3 million.
Sir, thank you, Mr. Chairman.
Thank you. Further questions of the Budget Director? Seeing none. Thank you, sir, for appearing today by WebEx.
Thank you, Mr. Chair.
Committee, we have no opponents, but we have one neutral. Eric Stafford with the Kansas Chamber of Commerce. Good morning, Eric. Welcome to Federal and State Affairs.
Good morning, Mr. Chairman and committee members. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. We appreciate the work that's gone into this bill over the last 2 years. Not here to really say anything other than we have had conversations with some of our members from some organizations here at the State House that there are some agencies that are using this as a reason to slow down the implementation or approval of regulation, and we hope that that would not be the case. And so I don't know if there's a way to potentially put in a time certain approach to this, but I think the changes that have been made will make the process more efficient for the budget director. We support those changes, I think based on input last year from Mr. Tymeson and Mr. Stuckey as we've had conversations on this. So biggest key I want to mention is just making sure that we don't use this law, or that this law isn't being used to slow down the approval of needed regulations. So that's all we want to say on the record. Be happy to answer any questions you might have.
Thank you. Questions?
Thank you, Mr. Chairman. Mr. Stafford, did I hear you right that there are agencies using this to slow down regulations?
That's what we've been told, Representative.
Who?
I'll get that to you.
I say who, I don't mean who told you, I mean which agencies are doing it.
Yeah, I'll confirm that and send that over to you.
Thank you. Thank you, Mr. Chairman.
Thank you. Could I ask you to also send it to Connie so we can get it out to other members?
Sure.
Thank you. Yes, Representative Heiberger.
Thank you, Mr. Chair. Did I correctly hear you say that you don't want to slow down the implementation of regulations?
No, I think we don't want this law to be used as a crutch to slow down regulations, that there are the approval process, going through the process to ensure that there's not a strong economic impact, because the whole purpose of the law that was passed in 2018 was because state agencies weren't doing proper, thorough analysis of the economic impact on business and industry in Kansans. And now we fear that there are some examples where they're saying, well, because of this law in place, it's taking a long time to get done. When the regulations that industry supports are needed, they acknowledge that they're needed, but they're not, they're slow rolling the implementation of those needed regulations under the auspice of this law, if that makes sense.
Further questions? Seeing none, thank you, sir.
Thank you.
Chair directs you to your daily agenda. There's a number of written neutrals. Kansas Cooperative Council, Kansas Grain and Feed Association, Biofuel Association, Assistant Secretary of State. Anyone else appearing or in the audience that would like to testify on House Bill 2087? Seeing none, I will close the hearing on House Bill 2087. Folks, you will see this tomorrow. Representative Heiberger, did you get that? Thank you. We're going to open the hearing on House Bill 2088. Reviser, if you would give us an overview.
Thank you again, Mr. Chairman. House Bill 2088 would amend the Kansas Code for Care of Children concerning investigations for child abuse or neglect. The bill would require that any investigation of an alleged victim of abuse or neglect be visually observed by the employee of the Kansas Department for Children and Families or the law enforcement agency investigating that report. The bill would also provide that in the event of a joint investigation by DCF and law enforcement, both would be required to visually observe the child. And all investigation reports required by the bill would have to include the date, time, and location that any such visual observation of a child occurred. And I'd be happy to answer any questions.
Questions for the reviser? Seeing none, we have two proponents. The first will be Representative Reese. I will just say good morning because you're here every day, so I need not welcome you to federal and state affairs.
Thank you, Mr. Chairman. And as you brief yourself on my testimony, I must apologize. I did this in much haste because I didn't realize, I always forget because I'm not much of a, I don't, do testimony very often, but Connie reminded me that if I wanted to submit testimony, I better get it done. So that's why it may look like it does. But today on 2088, I bring you, this is a bill that had passed 2 years ago in 2019. It came out of committee, amended to allow people who were in the household of the abused children and were 18 and over, in case they themselves were abused, weren't aware of the situation, and not make them all culpable based on maybe the time of residency in the household and what they recognize as abuse. And one of our esteemed members brought to our attention that in the Warren Jeffs situation, where children are raised up in an abuseful situation, they don't recognize abuse even when they reach a certain age. So we had to amend this bill to kind of temper down the intent of just everybody reporting. But the problem is that what we saw with little Adrian Jones in his household, little boy that 7 years old, abused, kicked, starved, tortured, made to sleep and live in a shower stall, that he had an uncle he had to hide from so that couldn't drink water, couldn't eat food. And the film shows this little boy running around in the dark, hiding from the uncle, who was the brother of the father. This little boy was abused to death by a stepmother and father. Ultimately, he's labeled the little boy was fed to the pigs. Kansas City, Kansas, my home county, we have a lot of things that go on. This is one of the most horrendous things that we remember happening to children. It's sad that this happens, and this recently, last summer, we had a little girl, 3-year-old, Olivia Jensen, whose father reported her missing. Subsequently, the authorities found out that he was the one that killed her and hid her body maybe about a mile north of the location over in Kansas City, Kansas. If you realize what we can do to help layer a protective measure for these children under abusive situations, you know, we can't turn the blind. This happens too much, especially now with all the strife times we're going through with the COVID and other situations happening, mental health issues. Children suffer the most. They have nobody to go to bat for them, so that's what I'm here to ask you to do for today. I know that Adrian's grandmother's here today. She may want to testify. So I ask you that when we report this out, the committee and work this bill, we report out favorably, It was below the line last year. It was above the line the year before in 2019. But I had a sudden death emergency, and we were scheduled to work it today, and I had to leave. Chairman postponed the hearing so I could come back and do it, but I wasn't able to make it back in time to run the bill. So hopefully we'll get this done this year, and ask your indulgence and your support. And with that, Mr. Chairman, I will stand for questions.
Thank you. And Representative, I'm glad you're back. For those who are unaware, he had an accident, a slip and fall, I guess is what we would call
I'm going
it.
to sue my wife, sir. So.
Okay, it's called a friendly lawsuit. But he was out a few days. We're glad to see he wasn't seriously injured, and we're glad to have you back. Questions for the conferee? Seeing none, you must have done a good job.
Thank you, Mr. Chair. Thank you.
Thank you. We have one other proponent, Tanya Keys, Deputy Secretary, Kansas Department of Children and Families, by WebEx. Yeah, are you there?
Thank you, Chair. How's my sound?
Please go forward.
Thank you. Thank you, Chair Barker and the committee for an opportunity to present information and support for the proposed changes in House Bill 2088. You heard a little bit about the proposed changes, but just want to make sure that folks know that this bill is about statutes that regulate child abuse and neglect investigations. Very specifically, it would require a visual observation of alleged victims in child abuse or neglect as part of a DCF or law enforcement investigation. DCF stands in support. We are a proponent of this bill that requires visual observation. This bill is consistent with existing DCF policy and procedure, and that's why DCF is pleased to support this important bill. A little bit of history. Statute requires that the Department for Children and Family receive and investigate reports of child abuse and neglect, and those come to us through our Kansas Protection Report Center for an evaluation on if we can go further. When those are assigned, we do have a worker go out and complete the investigation. And very specifically, our current policy already requires that we observe an alleged victim. When physical abuse or neglect is alleged, the child's body shall be observed or examined for evidence of physical trauma, which might be bruises or burns, but also the physical condition, so health and hygiene, those types of pieces. So our existing policy already includes this. This effect of the legislation would require visual observation, and as previously mentioned, if the circumstance is such that it's a joint investigation between DCF and law enforcement, both DCF and law enforcement would be required to do visual observation. In terms of the fiscal impact of this legislation, our policy already requires these tasks and actions, so there is no fiscal impact for the legislation to our department. The Department for Children and Families continues its commitment to ensuring safety, and that's why we are a proponent of this bill. It codifies our existing policy. We appreciate the opportunity to speak on it today, and I'm happy to answer any questions.
Thank you. Questions? The Deputy Secretary. No questions, and thank you for appearing today. Thank you, ma'am. Committee, I would direct you to the written proponents, Lori Ross, Foster Adopt Connect, Rachel Marsh, Children Alliance of Kansas. Those are the proponents. We have listed one opponent. My ranking member just indicated that the grandmother of Adrian is here. Does she wish to testify? You can come up. I would ask that within a day or so you send us a written testimony so that we can incorporate that into our record. Okay. Thank you, ma'am. You may proceed. First, introduce yourself.
My name is Judy Conway, and my grandson is Adrian Jones. And as Representative Ruiz mentioned. He was abused, tortured, and starved to death in 2015 by his father and stepmother. As Ruiz also mentioned, that living in the home was the uncle to the father, Mike Jones, who I firmly believe was aware of the abuse that was going on, and he failed to report that. I think it's imperative that this Adrian's Law is passed to put an extra layer of protection for our children. And I hope and I pray that this is the year that it finally gets passed. Thank you.
Thank you. Would you stand for questions?
Sure.
Thank you. Do we have questions? Seeing none, thank you again.
You're welcome.
That concludes all the proponents. I will move, there are no neutrals. I will go to the opponents. Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Police Officers Association. Good morning, Ed, and welcome to Federal and State Affairs.
Thank you, Mr. Chairman, committee members. I appreciate the opportunity to address you on this matter this morning. Mr. Chairman, if I could, I know you have some new members. I'd like to just give a brief introduction of myself. I am a career law enforcement officer. I was on the Lawrence Police Department for 2 years, 35 years on the Topeka Police Department. The last 5 of those years on Topeka Police Department, I was the chief of police. And 5 or 6 years prior to that, I was the deputy chief. After I retired, I branched into a new endeavor through our associations, representing them at the state legislature and the state agencies. Mr. Chairman, I want to start my testimony by expressing how important these cases are to us, where we have accusations of children being abused or neglected. And that certainly is not the point of our opposition. Our testimony is not concerned, based on the concern of the basic principle of what's being asked here. What our concern is that there is a little bit of lack of clarity and the practical application of what is proposed here when it mandates this in every single case by law enforcement to lay eyes on the victim or alleged victim in these cases. I want to also make clear we're responding to this from the law enforcement perspective, not the DCF perspective. Those may be different, and I want to just make clear where we're coming from on this. It is clearly good investigative practice to make physical contact with our victims of violent crimes, and especially our children, when we can and where it's practical. There's no doubt about that. Our concern is with legislative investigative procedures into statute. When you place those into statute, they become very rigid, and in this case, it requires this contact in every single case without exception, and that's where we have a concern. Our associations have, for the last several years, opposed this kind of legislated investigative procedures and relied more on requirements to develop written procedures within our jurisdictions. And there's good reason for this. One, investigative procedures need to be fluid. There are a lot of different ramifications and details of a case that requires us to approach them differently in each particular case. In these cases, we have to look at our local resources and make sure that we can handle the caseload that's being presented within our local resources and how we can coordinate those resources, not only to make it more efficient for our investigation and more thorough, but also we've been trying very hard over the last few years to create a victim-centered approach to investigations of abuse, neglect, sexual assaults, and things like that. And so we have to take into consideration the impact of our contact will have on this child. We rely very heavily in our investigations when we contact a child with the child advocacy centers. They have trained professionals who know how to approach these children to make sure we are getting the truth from the child and not something that's been fed into the child. But more importantly, to minimize the psychological impact, negative psychological impact we could have on that child if we don't approach this delicately and properly. And so in some cases, we will not lay eyes directly on the child, depending on the circumstances. But we rely on other professionals who do that and do it better than we can train our 8,500 law enforcement officers across the state to do. So it's very important to us that we do these things, but it's very important to us that statute not bind us in a way that could create liability. If we have a statute that says we have to do this in every single case, and we don't for whatever reason, we could be confronted with a liability issue. We will probably be able to defend that, but it's going to be costly to do. Other examples of where we might not make contact with a child, I had several of our members tell me in preparing for this testimony that they've had numerous cases where they get a report of an abused child, and that child is no longer in the state. And so what we do is we rely on out-of-state agencies. We talk to them and have them go try to make contact with the child. But this bill says it has to be done by the investigating agency. And so it's that kind of firm, mandatory detail in this bill that concerns us. So again, we're not opposed to the principle that's being requested here. We're opposed to the rigidity of putting investigative procedures into statute. And Mr. Chairman, I'll stand for questions.
Thank you. Questions? Hi, Representative. I'm sorry. Go ahead, Ripon.
Thank you, Mr. Chairman, and thank you, Mr. Clump, for being here today. And would the word may instead of shall in some of the scripts under the bill alleviate some of the burden you feel that's imposed on law enforcement?
The preference that we have is to take the approach we've taken the last several years on important investigative issues like this. If you will look in Chapter 22, I believe it's Article 46, you will find a series of statutes that direct law enforcement to have written policies on particular topics. And in those, it dictates a minimum points that have to be included in that policy. And we like that approach because it alleviates the liability concern, and it also allows us to work with our partners in our communities and with resources that we have available to us in our communities to best frame how we do that. For example, in this case, we would work with the prosecutors, we would work with our child advocacy centers, and even mental health resources that we have in our communities. And as you know, in some of our communities, those resources are rather thin. And so it's very difficult to create a cookie-cutter approach of how to do this, but that's our preference of how to deal with these matters.
Mr. Clump, if you and I could meet and maybe discuss possibly adding an amendment to this, would you be willing to do that?
Absolutely. I'd be glad to have that discussion and share that with our associations.
Perfect. Thank you, Mr. Chair.
Thank you. And I would ask that if you develop an amendment, run it by Representative Smith here also, who is familiar with these type of investigations. Representative Howe, do you have a question?
Yes, thank you, Mr. Chairman. Mr. Clump, thank you for being with us today. You had mentioned this legislation, if enacted, would limit you in working with other law enforcement in other jurisdictions. So if there was a report in Shawnee County, and say the child was now in Jackson County, Missouri, does this proposed legislation prohibit you from working with the authorities in Jackson County, Missouri?
It doesn't prohibit us from working with other law enforcement authorities, but it doesn't meet the standards of what's written in this bill. If you will look at page 2, lines 35 through 38, it specifically says, the law enforcement agency that is conducting the investigation shall visually observe the child who is the alleged victim. It doesn't say that we have to assure that that child has been examined. And for example, sometimes these children are critically injured and they'll be in a hospital under medical care. We know they're getting care and we know those injuries are being documented, but we will not go into the hospital child ICU to lay eyes on that child. So that's our concern. It's not that we cannot work with those other agencies. It's that when we do that, it doesn't fulfill the written requirement that's in this bill at this time.
Thank you. Further questions? Yes, Representative Miller.
Was there someone ahead of me? Thank you, Mr. Chairman. Chief, you mentioned that out of state as an issue, and as I recall the Adrian Jones case, that was one of the big problems, is that Missouri and Kansas officials were bouncing responsibility back and forth and no one was taking responsibility. Am I accurate?
I'm not informed on the particulars of the case, but from the media reports that I recall, I believe that's accurate. I don't know if it's a law enforcement arm or DCF investigators that were having that difficulty.
And I would think that this language would address that because it would make our law enforcement agency directly responsible regardless of whether the child had been hustled out of state.
Well, as I just explained, I think if the intent is that through the investigative process, we assure that somebody takes a look at this child, then that's fine, but that's not what the wording of the bill says. The wording of the bill says the investigative agency, which is us, whoever gets that case, must visually see the child. Not that we can work with an agency out of state to see that child, or that we can assure some other professional, medical professional, whatever, is seeing that child. And that's our concern.
And just a short comment, I don't see that as a problem. I see the problem that right now it's too easy to pass the buck. Thank you, Mr. Chairman.
Thank you. Representative Wagner.
Thank you, Mr. Chairman. Mr. Klump, in looking at your testimony, I want to clarify one thing, that you're saying that in fiscal year 2020, there were over 66,000 allegations of child abuse that came from mandatory reporters or whatever. So would it be your understanding that this bill would mean that all 66,000 of those allegations, you would have to make a visual report or visual contact with that?
Thank you for the question. The 66,000 is what's reported to DCF's report center. That includes all reports, not just those of mandatory reporters, but my understanding is the bulk of those are mandatory reporters. That's a point of, I think, our association had with some of the clarity in this. It talks about any investigation. Well, any investigation seems to be all 66,000 of those. DCF has a screening tool they use, as I understand it, to decide which ones are actually assigned to investigators. I'm not completely familiar with that, so I don't want to go into a lot of detail, but that's my understanding. I don't know the numbers of these cases that get referred to law enforcement, and I don't know the number of these cases that immediately come to law enforcement rather than DCF, and then we have to report them to DCF. But I know there's a significant number of these cases that we receive the first call on and not DCF. But I don't know what those cases are. And as you can imagine, when you get into the more populated areas, the numbers are larger. And so I just can't give you a number.
No, thank you very much.
Thank you. Further questions? Seeing none? Thank you.
Thank you, Mr. Chairman.
I have no one else listed as an opponent. Any other opponents appearing? Seeing none, I would direct the committee to written only on the neutrals. John Goodyear, the League of Kansas Municipalities. Anyone else appearing today that would want to offer testimony on House Bill 2088? Seeing none, I will close the hearing on House Bill 2088. That is the only two bills that I have. I will ask the committee, tomorrow we will meet, but Representative Epley has indicated he wishes to withdraw. If you explain that, you'll be filing another bill?
Thank you, Mr. Chair. Thank you, Mr. Chair. Yes, I plan on filing a new bill.
Okay. So we will not be hearing that bill tomorrow that's listed. We will be working the Rules and Regs bill tomorrow. And of course, bill introductions, and I think we're going to have a couple of bill introductions. And on Wednesday, we're doing a couple of alcohol bills that this committee has previously heard, and we're again under the line last year and never got the opportunity to be heard on the floor. Thursday, I am resetting some additional bills, so look to your change in the agenda for Thursday. Don't anticipate working Friday at this time. Anything else for the good of the committee? Yes, Representative Miller.
Thank you, Mr. Chairman. I see on the calendar that today is a deadline. Would you explain to those of us that are freshmen what that translates to? Because there are deadlines and there are deadlines, and I think that one, it would be helpful if we had some explanation.
This is the deadline for individual representatives to introduce a bill, I believe. Is that correct?
I think it's the deadline to request the
bill introduction
of the reviser.
The reviser. This is your last day if you want to get, if you're dealing with the reviser. If you've already asked them and you're working on the bill, that's okay. But you, after today, you cannot ask for them to draft another bill as an individual. And you can look at the Speaker's notice every week, his ad astra, I believe it's called, and it has all the deadlines at the end of it. We have bill turnarounds, we have committees, the non-exempt committees have a certain amount of days to introduce bills and work bills, and if they don't do it within the deadline, then they are not worked after that deadline. So all the freshmen, I think you had a class on that. Probably Representative Miller missed that class. But
Mr. Chairman.
We have classes for the freshmen on deadlines. Anything else for the good of the committee? Yes, Representative Heiberger.
Mr. Chair, are we working any bills tomorrow?
I think we are, so be alert, be here. All right, good enough. Anything else for the good of the committee? Seeing none, we are adjourned. Thank you, folks.